All right, welcome back. Thank you so much for staying with us. Being a Tuesday, we talk matters law, and today we are having a very pertinent discussion this morning on workers' right versus employer power. What do you need to know about, your rights at work, and if at all you have any powers over your employer, which I'm told that most of the time it's the employer who has most of the rights over the employee, because now you depend on your employer. So we have Wakili Ruth Tanui, an advocate of the High Court of Kenya. She'll be walking us through everything we need to know with regards to what the Employment Act entails and how you need to protect yourself as an employee and, of course, as an employer as well. Because sometimes we have cases where employers are also exploited. So we'll be looking at that in details. And the question we're asking you this morning with regard to the conversation we're talking about, which is workers' right versus employer power. If we have the question of the day. But we do encourage you to talk to us on our socials, TV47 Kenya on Facebook and on YouTube, on X at TV47 Digital. You can call in live and you can send us a voice note or a video of yourself at 0793267279, and we'll be happy to hear from you. Wakili, karibu sana.
Thank you for having me.
All right, when we talk about workers' right versus employer power, looking at it legally, what would you say that an employer need to know as far as their rights are concerned, or employee?
Okay, so I think with the power, it's the employer who has the power.
Yes.
But when it comes to the rights, the employee has been protected by the laws, the Kenyan labor laws, like for instance, the Employment Act, as even the Constitution of Kenya has protected the employee in regards to their rights. So that's why it's important for the employer to know the employee rights to ensure they are not infringing on them, because of course it normally ends up to them compensating employees who end up going to court. Yeah.
So that we can just get it out of the way. So is the employer also protected? Because like I started by saying that sometimes we've had cases where employers feel like they are exploited. If, for example, maybe an employee is saying just false things, if at all, maybe they are declared redundant or maybe their contract is terminated, just issues between employer and employee. So is the employer protected?
Yes, the employer also is also protected but most of the things lie on the employer. For instance, if there is an issue for maybe an employee is claiming that they have not been paid their salary, the law under the Employment Act assumes the employer keeps records. So if the employee is saying they have not been paid, if as an employee you have kept records and you present it, let's say it's before court, and you have evidence to show you have been paying this employee their salary, at least now you have protected yourself as an employer. So I think sometimes employers, maybe they bait themselves by not, like, for instance, keeping records, or for instance, having a contract. Because, sometimes an employer might feel like not having a contract protects them. But remember, in the contract, you state all the terms that you have. It protects both parties. So in case of anything, like let's say, for instance, it's a fixed term contract that's supposed to end in 31st December 2026. As an employer, if you made it clear in your contract that the contract ends in December, at the end of December, the employer cannot come and claim that they thought their contract is continuing for the next year. So the employers also have their rights, but now most of them, I think because I think the power that comes with it, or maybe they don't understand the law. That's why you find in most instances, the court will always go. I normally tell people when we're in court and the employee is claiming they're not given house allowance, and the burden shifts to the employer to bring records. If they don't bring records, the court automatically states that gives the employee the house allowance, because now it's on them. That's why I feel they are protected if they keep records, and of course if they have contracts, they ensure they protect themselves.
So evidence is important all the time.
Yeah.
Do you think workers in Kenya really understand the rights that they have, or is there still an information gap?
There's a serious information gap. Most people don't understand their rights under the Employment Act. As much as these laws have been put to protect both parties, you find for instance, the employees don't know their rights to, for instance, you have a right to have at least, you can't work for the 7 days. You're supposed to rest at least for one day of the 7 days of the week. You have a right to leave days, a minimum of 21 days leave. You have a right to, but most employees normally don't know. Even there's minimum wage that the law provides, but most people are not even aware of how much the minimum wage, especially for the unskilled, it normally applies to the unskilled workers, the casual workers. Most of them don't even know. Like if you don't know as a watchman that my minimum wage is, I think according to the minimum wage, it's around 17,000, but you're being paid 10,000. If you don't know, like it will mean that you don't know even your right is being infringed. Yeah, there's serious misinformation, because sometimes when you share maybe content online about employee rights, someone will come to your office saying, I didn't know my rights had been infringed. It's until you shared this. Yeah. So that's why I feel there's that serious gap. Yeah.
So when you talk about sometimes, and you've mentioned a lot of things, but I want to start with this. When you talk about sometimes, the minimum wage gives 17,000, but somebody is being paid 10,000 Kenyan shillings. What recourse do they have? You know, can they go to maybe the employment and labor courts to just, you know, petition for their rights if that's something that is possible for them?
Yeah, so me, I normally advise, if you're still, you know, it depends, if you're still having the employer-employee relationship, you can go to the labor office. And now most of the time, most labor offices, your nearest labor office from where you're working, and then now you let them know that you're being paid below minimum wage. And most of the time, the labor officers will reach to your employer, yeah, and bring out that issue, and now, of course, negotiate for you to get your normal wage. Then now, most of the time, what happens when when now someone has been terminated is when now, especially now maybe a lawyer has been involved. Because now if you come to our offices, we'll know you have been paid since maybe you've worked for 8 years, we'll know you have been underpaid. So we normally seek for the underpayment, the back pay of the underpaid. And the court normally awards it. So long as there's evidence to show you are being underpaid. So if you're still working in your workplace and you don't want to ruin that relationship, I think normally you can go to the labor office. But according to the law, so if you go to court, your employer is not supposed to terminate your services based on you going to court. Yeah. So, but I would advise maybe start with the labor office. But what also people should know is you cannot do labor and courts together. Those are two institutions that solve employee issues. So you can't go to the labor office, then also do court. If you have decided the labor office route, you have to follow it until the end, unless maybe you're not, let's say you don't get satisfied with the decision, or maybe they don't actually solve the problem, is when now you bring the case to court. Yeah.
So what you're saying is, you know, sometimes when I have an employee, right? Yeah. They take me to court. Of course, I'll be aggrieved. I'll feel very sad about it. So I have to still retain them and look at them every day and not terminate their contract. Yeah,
because now if you are to terminate, what will be the grounds of termination? Because remember, under the law, it has to be lawful termination. You have to be there has to be a reason why you're terminating the employee. Your reason cannot be it's because they took me to court. Yeah.
Of course, we'll be talking about the process of termination in details later. But in that case specifically, what if I say that maybe, you know, we're not getting along anymore? Like I feel like, but you know, my employee being here, like we have nothing to talk about. You have no relationship. Naona anaweza nimaliza, naona anaweza mmaliza. You know, such cases. Isn't that grounds for, you know, a termination or just letting go of my employee?
No, that's not. It will be unfair to there has to be a good reason why you want to let go of your employee. So, but you can decide if you enter into a mutual separation agreement with the employee.
Yes.
But it has to be with consent, and all parties have to be on the same page. Yeah.
You mentioned something quite interesting that I'd love clarity on. That, you know, sometimes people work for 6 days and it's okay. So, that in the 7 days that we have, then it's okay to work for 6 days. You know, sometimes when people tell me that they work for 6 days, I get so shocked. I say, why do you work for 6 days? I think it should be 5 days, then you get to resting days. So the law actually puts it that working 6 days is okay.
Yeah, but it's not mandatory. The law just gives the law has just stated you have to have at least one rest day in a week. But now you can decide, you can change the terms. It doesn't have to be, like, it's not like the Bible, like you have to, but now the law has already said 1 day. You can't go below 1 day. It can't be 7 days. So you can decide to give 2 days. It depends. Now the agreement you come with your employer. Yeah.
It depends with employer to employer.
Yeah. So you can decide, most even people, I think they work from Monday to Friday. Some work maybe from Monday to Saturday, half day. But now the law states that you at least have to have 1 day. Sadly, there are people who work from Monday to Sunday. Yeah, they don't even get that one rest day. But the law stipulates that you have to work. That's why when you go to sue, if the person who, now our client was working, we have to seek for that compensation where they are working.
7 days?
Yeah, 7 days.
Okay.
Yeah.
So if somebody is
that will be overtime.
Overtime. If somebody is seeking compensation, say they've worked for 7 days, then how is that process done? Like, you know, how are they paid? Is there a minimum amount?
Yeah, there's normally it will depend with your salary and the number of the period you have worked in the company. So there's the way it's calculated. So what you just do, we do a calculation back, let's say you're earning 50,000 per month. We'll do a calculation of 1 hour. And you know, normally 8 hours working day. So we'll use that calculation to do the math, to bring out like, if you worked throughout the entire period, or some you may find there's days you didn't work. So it will depend. That's why we'll do just the calculation based on it. Yeah.
Talk to us about some of the sections in the Employment Act that you find that a lot of Kenyans violate in workplaces.
So I think the most common one I can say is Section 42, probationary contracts. What people don't know is Section 42 has been found to be unconstitutional. Before, probation contracts, you didn't have, first of all, the employers normally, you know, under the law, maximum is 12 months. So you start with 6, you can extend to another 6. If you don't, if you don't either terminate or confirm the employment of the employee during that period, the operation of the law, that becomes permanent and pensionable employee. That's another thing most people normally, they fail to understand it. And normally under the Section 42, right now, it stipulates that you don't need to follow the normal procedure in terminating. You don't need to follow the giving notice and everything. But there's a 3-judge bench that already decided that's unfair. So that's why normally say as employers and employees, you need to be up to date with the emerging trends with the employment matters. So I think that is the common one. And the other common is that they don't follow the procedures under Section 41 of the Employment Act, following the normal procedure on terminating an employee. Most people forgo that part. So and you know, people normally assume it's gross misconduct. Gross misconduct is, for instance, someone comes, like now even in this workplace, drunk. You know, under the law, it has stated that's a summary dismissal. So some employees people make the mistake of terminating someone on the spot. The law is against that. You have to give someone an opportunity. So give them a notice to show cause, let them explain themselves, then have a disciplinary hearing, then make a determination. It can be an absconding duty. Like it's obvious this person has missed coming to work. So people normally have the assumption that if someone has absconded duty, you can't, like, it's automatic, you terminate them. But you need to give them an opportunity to be heard, whereby you follow the procedure. I normally give example of cases where you're justified on why you have terminated the employee. Like for instance, there are cases where, for instance, someone came with forged documents to get a job. It was not in dispute, but now the mistake during the disciplinary process, these people failed. It was even the Judicial Service Commission that was terminating someone who brought forged documents. They didn't inform this person that they're supposed to come with a witness during the hearing. And just that court found that termination to be unfair. So it can just be some minor mistakes that people find to be, like, they see it as it's not a big deal, like I'm justified. And sometimes it makes sense. As an employer, this person has absconded duty. You're justified to let them go, but you have to follow the procedure. So people forgo those procedures under Section 41, Section 45 of the Employment Act. People forgo it. So they don't. And also certificate of service. It looks so simple, but you know, it's an employee's right to be given a certificate of service. Some employers feel it like, I don't have to give it to you.
That is what we know as recommendation letter, or
no,
this is something else?
There's a difference. Certificate of service is whereby if you have worked in a certain company for 5 years, someone just says this person was working as, let's say, a journalist from maybe 2020 to 2026. Yeah, just basically that certificate of service. You don't have, recommendation letter is not mandatory. You don't have to give someone. You may decide at your own will as an employer. But certificate of service under Section 51 of the Employment Act, you must give it to an employee. So some employers forgo that. Even sometimes, even if you have followed procedure as an employer, and then you just fail to give that certificate of service, that becomes an unfair termination. Yeah, because they are entitled to be given their certificate of service. Then I think another thing people forgo is there was an amendment to the Employment Act 2022.
Yes.
Whereby you don't need, as an employer, you can't ask an employee to give you, remember before you need all the clearance certificates, the certificate of good conduct. From the law has stated that you don't need, you're not supposed to ask an employee for those documents until you offer them a job. So some I normally still see they advertise and they still make that as a requirement. Yeah, so those are some of the things people ignore, but it's stipulated under the law. Yeah.
So if maybe a job now advertises that you know, there's an opportunity, but then they're asking for that good conduct, now that you say court had dismissed that particular part, then what can be done now with that? Because at the end of the day, mtu anataka kazi, yeah? And if they do not submit that particular document, then they cannot get that job, or they cannot even make the cut. then what do they do in that particular point? Do they just upload it to good conduct? Or?
But you know, it's if someone decides to sue them, they can sue them and they'll win. Yeah, because you're not required to ask for it. It's not mandated. It's just that, of course, people will look at, you know, you weigh even the legal fees and everything. So not a lot of people will actually take it upon themselves to maybe sue or something. But even for, I normally see, you see, someone can just, anyone, you know, I'm just thinking the way someone, you know, it's the law. It's a law that stipulates you can't give out, you can't ask for those certificates. So I normally see, anyway, Kenyans also fall prey to it. So sometimes you still see someone saying that. Because I remember when my sister was applying for some job, then she was telling me this company is saying that they need those documents like immediately before they offer you the job. And then they tell you, we need like 15,000 to get you those documents. So you see now already you're conning, people get, that's even why I think the law was stipulated to avoid people, like a lot of people are being conned based on that circumstance. Yeah, so to answer your question, I don't think a lot of people, of course, will, unless someone is, but no, it's risky for an employer, unless someone takes it, because if someone decides to sue them, they will actually win in court. Yeah.
Now that we were talking about termination and we're in that particular point, I'd love for you to walk us just in depth the process of termination, how the law, you know, considers it's right? Because when you talk about sometimes absconding duty is a valid reason to terminate somebody's contract, then what is exactly the process of termination? There's something else, redundancy, because these are two different things. So start us off with termination, and then we can now look at redundancy.
So for termination, we can use the example of absconding duty. What the court looks at is the substantive why did you terminate this employee? Let's say the reason was absconding duty. So then court now goes to the how. What process did you use? So what normally happens is you have to give, first of all, if there was an investigation and there's an investigation report, you have to give this employee that before the hearing. That's what most employers normally miss. You have to give this person the evidence you intend to use. If there was a whistleblower who came and maybe reported, you have to give and there's a statement that they recorded, you have to give the employee that evidence. So there's the notice to show cause. You have to give the employee the notice, basically informing them there's this allegation against you. So we are giving you, and also the timeline is very important, because the 1 day has been, employment courts have stated that 1 day is not enough for someone to respond. So depending on the circumstances. So you write a notice to show cause to the employee, and then the employee is given time. I normally tell people 3 days, 3 to 5 days, depending on the circumstance. Give them, let's say, 3 days to respond to the show cause letter. Then when they do then after they respond to the notice to show cause, now you'll see based on the response, you see if it's justifiable. If they don't give a justifiable reason that you feel you are justified with the reason, you now give them a notice to attend a disciplinary hearing. And you have to, in the notice to attend the disciplinary hearing, you have to stipulate that they can come with a witness. It's under the law. They can come with a witness if they want, or an employee of their choice. And then, you of course, you state when the disciplinary hearing is going to take place. Common mistake most employers make, you can't be the one person who investigated and you're the one who'll sit in the disciplinary panel. That's illegal. And then you also, if there are witnesses, you have to bring them to be cross-examined. The employee has a right to come and cross-examine them. So that's why there'll be a hearing. During the hearing, the employee will be given a chance to present their case. So let's say it was absconding, they might be saying, maybe I was sick. So did they present any evidence to show that they were sick? And no burden is normally on the employer. That's why we normally advise employees, when you get to this stage, remember the burden is, I normally say the burden is normally on who alleges. So some people normally make the mistake, employees. So now this is just free advice to employees. Some, they feel like, let me fight for my job. So they go and admit even things that they didn't, like they feel being apologetic will give them back their job. Remember, the moment you apologize and everything, it's like you're admitting to that. So the employer's job becomes easy. Yeah. So anyway, it will be opportunity now to defend yourself during the disciplinary hearing. Then now the employer will make a determination. So most of the, but I normally say most of the time, by the time an employer has done this process, 90% of the time it normally ends with termination, most of the time. So after now that you get the termination letter, and you normally have a right to appeal. Most companies have policies which stipulate that you have like 7 days right to appeal. Yeah.
With the courts, right?
No, with them. You know, you have a hearing, and then they'll make a determination. Most employers have policies where they give the employer right to appeal that decision. yeah, that the employer has made. Yeah.
So when you said cross examination, that what an employer is given a chance to cross examine the witness, we don't see that happening most of the time. What you're saying is sometimes if maybe a colleague of mine has issues with me and they report to me, then I should be put in the same room with them to also ask them questions.
Yeah, let's say for me, I'm going to report you to the now let's say we're working together and then I've reported you. You have a right during the hearing to cross-examine me. They can't go with what I've just said and assume it's the truth. Yeah, so that's normally, even those are the mistakes that most employers make. That's why you find most cases, that's why people even assume that the Employment Act has fully protected the employee, because now because of you might have been justified, this person absconded duty even for a month, it's not even in dispute, but now the fact that you didn't give this person an opportunity to give a fair hearing during the disciplinary process, that's enough for court to find that to be an unfair termination, and the employee will be compensated. Yeah.
So the employee will be compensated such that they will be paid by the company for, there's a term that they use.
Yeah, there's normally, court will compensate the employee. It's normally, the court has provided, the Act provides, that Section 49 provides for 12 months maximum. But now court will look at the circumstances. So sometimes if the process was so unfair, court sometimes will give them the maximum 12 months. But if maybe for such a situation where they were justified on the why, court might give 3 months, 4 months of your salary. So let's say if you're earning 50,000, it will be 50,000 times 4 for the 4 months. And then if they didn't give you a notice, payment in lieu of notice, you'll get now the 50,000 for the month. Yeah, and then those unpaid leave days, that's when even if the issue of underpayment, that's when it comes in. House allowance, because the law stipulates that you're supposed to provide house accommodation, but now it doesn't have to be real accommodation. It can be through salary. They just give you good compensation that includes house, where you can get good accommodation. So if it's not been provided, it's one of the things, compensation you will seek. This is now in court. So the moment court finds there's no fair termination, they compensate the employee. Yeah.
So I'm trying to think about it this way. Does the court see that as emotional abuse? For example, if the issue of cross-examination, if it's not done at all, and then they see that there was no fair, judgment in the, at work, so does court consider that emotional abuse, or what does the court call it?
No, it just considers unfair termination, because the law provides that it has to be a fair disciplinary process.
Okay.
And I normally tell court awards what you have sought for. In most instances, court will not give you what you have not sought for. So if you are claiming that your rights, now they're saying emotional, maybe of course you'll say your rights under the Constitution was infringed.
Yes.
Maybe right to fair labor practice. That's why you'll have to seek for constitutional infringement compensation for that. But now here for that process, court just looks like they didn't follow the procedure, the disciplinary process. Yeah.
Are there cases where court has ordered for that employee to be given back their job so that they can be retained?
Yeah, if the employer has sought for reinstatement. So if you went to court and sought for reinstatement, court will hear you out, hear the employer, and court now might determine now whether you'll be reinstated to your job. Yeah.
I'm trying to see how now that environment will be for the employee who has been reinstated. Is it always a safe working environment, or do you recommend actually for somebody to go back to that workplace where now, of course, there has been a case, they have taken the employer to court, they have won the case, and now they are back at work? Do you recommend such a scenario?
For such a scenario, it depends with now what is the purposes of why you are living, this incident even happened, that you're even in court seeking for reinstatement. But even in most instances, court will look at also the circumstances and the relationship now. If now they're seeing the relationship is no longer fair, for court may not request for reinstatement to be given. And then sometimes, most of the time when you're seeking for reinstatement, it has to be at the beginning. Because remember, I normally tell people cases take even 3 years. So it can't be something you've sought after the case, after the fact. Of course, this employer will have to get someone to do that job. So that's most of the time, if you're seeking for reinstatement, it's normally something you seek from the beginning. Yeah, when you're filing the case. So of course, if you're seeking for reinstatement, you won't seek for compensation for these damages, because you're going back to, most of the time you won't seek for this compensation because you're going back to work. Yeah. So basically termination will not have happened.
All right.
Yeah.
And when you talk about this case is taking 3 years, why does it take so long though?
It depends. I think it's courts. Like for instance, if you're filing a 8 million money, they have a lot of cases already. And also sometimes there's the issue of the judges or the magistrates are transferred. So the case takes longer. You may find you'd been given like for us, we had a case that we had in February. Then we were told the magistrate was transferred. They gave us a date in August. Like you just find in the system it has been updated to August. Let's say you don't have control over it. And then maybe that August, maybe the magistrate will not sit. Then you get maybe even, you may find when you get in December. So I think sometimes also it just depends with the court. But sometimes also you get lucky, but I don't think it's so rare that you get, most of the time the employment matters have done 3 years. Yeah.
Is pay cut justified? Say, for example, there are challenges at work.
Yeah.
Economy is bad, and maybe my employer sees that, now at this point, I don't want to send these guys home, right? What we'll do is that if I'm giving you, for example, that 50,000 Kenyan shillings or 100,000 Kenyan shillings, then I'm going to cut your salary to 50,000. Or if it's 50, I'm going to cut it to 25,000. Is that justified under the law?
For salary reduction is illegal under the law, but it depends if an employer does it with consultation with the employee. Like now maybe the business is not doing well, they have to consult the employee. Let the employee know that we want to reduce salaries to this amount. And there has to be evidence on their end. There has to be consultation. Yeah, but generally it's normally illegal to reduce an employee's salary without their consent. Yeah, unless they consent, that's okay. Maybe even do a written consent, maybe for a certain period. Yeah.
So what if they're consulted, but they're not for that idea? You've given them the reasons why you are for a pay cut, because maybe the economy is doing badly for everyone else. Everyone is affected. But now your employees are not in for that particular agreement. They're against it. And then you proceed, of course, to just cut their salaries. Then is that something that the law would find illegal?
Yeah, court will find that illegal if you go ahead to terminate an employee's salary. Because remember, if an employee goes and claims their salary was deducted illegally without their consent, burden shifts to you to confirm if you consented. So most of the time, even that's what I was saying, when you are seeking for compensation in court, most of the time when you have sought for salary reduction, if the employer doesn't justify it by saying that there was consent, and there has to be like written consent whereby the employee signed and admitted, or evidence just to confirm that consent, the court will automatically find that to award the employee the salary that was reduced. Because remember, this is breach of contract. When you entered into a contract with you, you're supposed to pay me 50,000. The moment you're going against it, that's already breach of contract.
Of a contract. Walk us through the process of now declaring redundancy. How are employees protected in this case?
So for redundancy, by the way, I normally tell people it's not an illegal process. It's just that how the employer carries it out. Because most times redundancy, it's normally involuntary in a way that maybe the company is undergoing, maybe it's closing up, maybe they're restructuring, or maybe they don't need that position anymore. So that's why redundancy is not but now the problem is an employee is protected if, because normally court requires, there are some processes you have to follow. You have to look at the skill of the employee. First of all, even this one, there has to be consultation with the employee. You have to consult with the employee. The employee has to, like for instance, now, you look at the skill set. So we cannot be, let's say for us, we're in the same industry and maybe the company is restructuring, and me, I've worked for 20 years. Then for you, they normally say last in, last out. First in, last out. So if I've worked in that company for 20 years and then for you joined a year later, you see now it will be unfair if I'm the one who is my position, I'm the one who lives before you. So court has to look at the process that you followed, the procedure that the employer followed. Another mistake employers do, I normally say employers, when they want to get rid of someone, sometimes they make the mistake of, you find for you your position has been declared redundant, like they no longer read your position, and then the next day you're seeing the position has been advertised. Yeah, there's even a case now, normally it's a famous bank, they did the same thing, and the employee was handsomely rewarded by court because there was evidence that that position was advertised after they went for redundancy, claiming that position was no longer needed. So I normally tell people for redundancy, it's not an illegal process, it's how the procedure now is when now the legality comes in. Yeah.
Talk to us about those employees now who choose to terminate the contract. In that case, does the employer have anything against them?
So normally, most of the time you find in the terms of your contract, there's a termination clause whereby it stipulates that each party has to give 1 month notice. So if the same applies if it's the employee who wants to part ways. So you give 1 month, maybe you want to resign, if it's resignation, you give 1 month notice to the employer that you're resigning from your position. Most instances, of course, the employer, unless maybe you don't give the 1 month notice, they'll make sick. Though it's so rare for an employer to take someone to court for not giving the 1 month notice, because now you'll pay them. If you don't give the 1 month notice, you have to give payment in lieu of notice. So basically, if you're earning 50,000, if you resign immediately, you have to pay them 50,000 to the employer.
Oh, you pay the employer?
Yeah, because now it's the same vice versa. Just the way if the employer does not give you notice, they have to pay you 1 month in lieu of notice. So even if you are resigning or terminating the contract, you have to inform them. You have to give 1 month notice to the employer, maybe to look for a person to replace that. So maybe, like, if you want to leave the company, let's say, maybe you've made a choice this March, you want to leave. You give them 1 month notice, then you leave now in April. So just give them the notice, then you leave in April. You give them time, of course, maybe to look for another employee. But now if you give a resignation letter that same day and you leave, the employer is justified to seek
to ask for payment
from you.
What if now I work halfway, right? Say the month has 30 days, but I work 15. You give me 50,000 and now I say I'm going to give you 25,000. Is that something that is doable?
Sorry?
Or I have to give you, you're saying that if I terminate my contract or if I resign before, you know, the 1 month notice is done, then what if now I choose to work it halfway, right? I want to resign by April, but I choose to work from 1st to the 15th of March.
Yeah.
So I give my employer 25,000 to let me go. Is that justified?
Yeah, you can compensate because at least you've worked for those 15 days. Yeah, it's justifiable.
All right.
Yeah.
Let's get some of the feedback so that we can see what the people are saying as far as our conversation of the day is concerned. Workers' right versus employer. The line between legitimate employer control and violation of workers' right. James from Nairobi says many employees know their rights, but they fear speaking out because they might lose their jobs. Employers still hold on too much power. Faith from Nakuru says the law is there to protect workers, but implementation is a problem. Many employers ignore labor laws and employees suffer in silence. In most companies, contracts favor the employer. If you complain about working hours or pay, you risk being replaced immediately. Grace from Meadowrest says employees also need to understand their responsibilities. Rights should go hand in hand with accountability at the workplace. Brian from Kiambu says the biggest problem is unemployment because jobs are few. Employers take advantage and workers accept unfair conditions. And from Kisumu says labor offices should be more active in protecting workers. Many people don't know where to report exploitation. So where do we report exploitation? Let's just start from that particular point there. Many people don't know where to report exploitation. And we've seen another comment that says, jobs are few, there's no employment, so employees just take whatever they're given because there's, hakuna kazi. So hao watachukua tu yenye iko.
Oh, so okay, the part for where to report any exploitation, I think the best is normally the labor office. Even in every, I can say in every county, there's normally a labor office. So that's normally the first place to report. But there's someone also stated, and unfortunately, most of these labor officers, because when you go to the labor office, you find labor officers are normally corrupt. That's the unfortunate part. Because most of the time when you go and report, this labor officer has now to reach out to your employer. Most of the time, the employer might bribe him. Then you find, because even most people who come now, by the time they come to a lawyer, they have been frustrated by the labor office. So I think also I feel like the labor office should be more vibrant in supporting the employee rights, because they're the ones even who are mostly on the ground. Because when you come before you file a case before court, it takes time. You need to get summons, you need to serve the other party. But not, for them it can be instant help. Because if someone walks into your office and you take action immediately, it's normally easier. So where you can report exploitation is normally in the labor office. But what I tell people, if you're not satisfied or you don't get help, there's normally now the courts. You can go to court. But now there's even someone who brought it up, that relationship, you already have the employer-employee relationship. Yeah. So someone is scared to lose their job. But what I normally tell people, an employer is not supposed to terminate you for reporting them to, like, fighting for your rights. Yeah. But of course, a lot of people will be scared to sue their employer or report such. Even some even talking about the labor office.
Yes.
Some even will be scared to go to a labor office to report their employer because they're scared of losing their jobs. But the laws are there to protect people. So I normally say, if you are under, because you know your rights. Of course, the worst that can happen is you'll be terminated. You lose your job. But and unfortunately, also the courts, they have said they can take 3 years. So it's not something that you'll go to maybe a lawyer's office and you're compensated immediately. So I think also I support the person who said that the implementation should be focused on. Like even for courts, but now there's nothing much that can be done when it comes to court, because now when you file the case, you don't have control as the lawyer filing the case. But I think it's the labor offices whereby there should be vibrance there, because I think they're the ones who are on the ground who can ensure. And the moment labor officers take their job seriously, a lot of employers will not be free. They will not infringe on employee rights. It will be hard because they know the laws are working. Yeah.
But where do you think the problem is exactly? If at all, Kenyans know they have their rights are protected at work, then could it be something to do with maybe money-wise, say financial challenges, such that maybe, for example, if I'm filing a case against my employer, then it will cost me a lot of money if you're going through that process for 3 years, for example. Is it anything to do with financial challenges?
Yeah, it can also be financial, because a lot of people will not afford, especially, remember the circumstances, it's chances that you have lost your job. So you don't have the finances to go to get a lawyer and the lawyer to, defend you in court. So most of the time it's normally also financial challenges for many people. So most people, they won't afford legal fees. Or even people have the assumption getting a lawyer is going to be an expensive affair, and someone just feels, let me move on with my life, let me just get another job and just move on with my life. Yeah, but I feel if more people fight for their rights, that's the best way to actually just ensure everything works. Because employers will feel free if they know you feel they can get away with it. But the moment a lot of people take it up to themselves to fight for their rights, someone said people know their rights. The moment you know your right, you can fight for your right. But many people are normally scared, of course, for losing their jobs and all that. But I feel the best way to fight it is people just standing up for their own rights. Yeah.
If we normalize it, then at least it will be somehow better.
Yeah, and it's so serious. Because if someone comes, they have the money to get a lawyer and everything, but they feel that the employer is so powerful, especially if they work for big companies. So they feel the employer is going to pay the judge. The employer is going to pay the judge. So they feel like it's not even about the finances, it's not about their rights. They just feel the employer is too powerful. Like, you can't fight them. But I normally tell people that when it comes to court, the laws are clear. Yeah, the court follows the law. It's not about, because I normally tell people, even if worse comes to us, of course, no one wants to go through that vigorous process of court. Because, for instance, that's why there are appeals. So if you're in the lower court and you feel it was an unfair judgment, you go to the high court. If high court, you go to the court of appeal. Yeah.
So do you have pro bono cases with, matters of labor, work? Are there pro bonos?
Yeah, they're normally pro bonos. And I think even most lawyers take up employment matters more of pro bono basis, but of course their compensation might come in at the 30% of the award from court, when the employee is awarded damages. Yeah.
Let's talk about the legitimate powers that an employer has over an employee. Because now, one of the comments say that employers feel like they have so much power over employees. Now the employees fear coming forward and, of course, reporting their employers or maybe suing them. So what powers do employers legitimately have over their employees?
I feel even the first one is resources. Even the moment you start that relationship, the employer is the one with the more power. Remember, everything comes from the employer, even the contract. When you go and sign the contract, someone is normally desperate for a job. Sometimes you find, even as much as the contract, you may find someone even has, you have like 7 years experience, but now because you're desperate, you will get a job and you're paid 30,000, which of course is not like the amount of salary you're supposed to get based on your skills and your kind of education and everything. So I feel the employer will have more power, because now you may find so that's why the employer will take advantage of that, because for you are coming in from a point of you really need that job. So the employer will draft the contract, and the moment you sign the contract, so there's no way the blame does not go to the employer. So I feel that's where, and remember that it's legal. like as much as this person is being underpaid, it's still legal. Yeah.
At what point does managerial authority become abuse of power, Akili?
So I think managerial authority, mostly you find people with money, like even when it comes to now, someone might just decide they don't like you in a company. And because they're in a position where they can terminate you, they actually terminate you, or they just frustrate you. So that's why even court nowadays, the law does not provide for constructive dismissal, but people normally sue for constructive dismissal. It's where the managerial, even we have had cases whereby the people in managerial position just frustrate someone because they just don't like you. Maybe you don't bend the laws here and there. You're too stringent, so they just want to get rid of you. So they take advantage of that power. So you find they just frustrate you, hoping you'll resign. So the moment and then if you don't resign, they just create something for you to just be terminated. So I feel that's serious abuse of power. So you find some serious people who are good at their job and everything, they lose their job just based on people who just feel they have that power.
Talk to us about written contract. And I saw this comment somewhere that can you sue someone or maybe your employer if you worked for them for some time without a written contract, or unafanya tu kazi but you have no written contract, can you sue them for that?
Yeah, you can sue your employer, but you have to have evidence of an employer-employee relationship. No matter if an employment court deals with employment matters. So there has to be an employer-employee relationship. But it can't only be proved through contract. So maybe if they were doing statutory deduction, like in NHIF, if they were being was being paid, that's another evidence you can show there was an employer-employee relationship. If there was salary payment, you're being paid salary there's no way you've been paid, maybe you've worked for 5 years and they're paying you salary. That's already evidence for a relationship. Yeah, so you can still sue your employer.
Even through M-Pesa? If you're being paid even through M-Pesa, that's still evidence
so long as,
enough?
So I hope it's from the company. It will make more sense if it's from the company. Yeah.
And not somebody maybe from Anne Odida to Ruth Tenui. That will not be evidence enough. It can become,
yeah, but now of course it will also depend, because imagine if you have sent me for 5 years, but then now will shift to you to show that I'm not. But that's the first thing. I normally tell people that's the hardest thing. Sometimes someone walks into your office, but they cannot prove that relationship. They have nothing. This employer is not doing statutory deduction. This employer was paying salary in cash. So you have nothing to prove that relationship. So we normally say that it's a case that's already dead on arrival. Because of course the other person, the employer will lawyer up, will get a lawyer, and the lawyer will come and, burden is on you, show the relationship. And I might tell people, as much as you know deep in your heart, it's the truth, you're working for this company.
Yeah.
This is a judge or a magistrate who doesn't know both of you. So the only way they'll know this person is saying the truth, or this person is saying, the employer is saying the truth, or the employee is saying the truth, is evidence is brought. Yeah, so if you don't have any evidence to show the relationship, so it becomes hard, because you find most people, they do this informal agreements.
Yes.
Yes, we call them the gentleman agreement, handshake agreements, whereby I'm working for you, but we don't have anything to show. You don't pay for me statutory deduction, you don't do pay. You pay me in cash, like unanipea bahasha every end month. Then it will be hard for me to prove that I'm your employee. Yeah.
So is it mandatory for every employee in this country to have a written contract?
It's not mandatory, but the law provides for it. It's not mandatory, but under the law, like under the Employment Act, the employer is supposed to provide a contract between the parties. But there's no penalty for not providing for it. It becomes now consequential to a party now, that, especially now for the employer. If there's no contract, like now that cannot be used against an employee, stating that because you don't have a written contract, it means there's no employer-employee relationship. Yeah.
Does this also apply to domestic workers, maybe back home, maybe my house manager, say my shamba boy, somebody who does 1, 2, 3, just small things for me at home? Should I be giving them a contract just in case maybe one day they want to take me to court and I need evidence? I know we talked about evidence. Sometimes for that employer-employee relations, for my house manager, should they also have a written contract?
Yeah, it applies to them. So it's normally advisable to, so long as they're working more, they're not casual labor, like you not hired them casually for 3 months, which is normally from 0 to 3 months. It's normally advisable to have a contract in place. I normally say this, it protects both parties. And even as you as employing your house manager, it also protects you. Because now the contract is clear, you put the JD, job description, the hours, in case, now, if you want to part ways, it's clear on how that is done. So, for instance, now you've said termination. In case of termination, you give each other 1 month contract. 1 month notice. So I think it's normal, it's advisable to have contracts. It protects both parties. Yeah.
Talk to us about contractors out of a statute, right? Maybe sometimes the Employment Act states that the minimum days that somebody should get their leave maybe is 28 or 21. You tell us about that. But then, for example, where I work, they tell me that I'm only entitled to 15 days of leave. And maybe the entire period of a month, maybe just sick leave, or maybe just maybe 1 week or 3 days. I don't know what happens with that. So what supersedes the other? My employer or the Employment Act? If the Employment Act says that I am entitled to 21 days of leave or 28 days of leave, but my employer only gives me 15, what supersedes the other?
It's statute. The law supersedes even the law stipulates that any policies or any procedures that the employer comes up with, it has to be in line with the Kenya labor laws, which includes the Employment Act. And the Employment Act gives a minimum of 21 days. It can go below 21 legally. If you want, you can put 26, 28, but the minimum, the law is clear, its minimum is 21 days. So in a situation where you're being given the less than the minimum that the statute has provided, now this is when I normally tell, if you come now, let's say you're coming for a consultation, we give you options available for you. You can start by writing to your employer requesting that you be given, at least the minimum according to the law, or you can go to the labor office the way I stated, based on, depending, or you can even, you have a right under the law to, you can sue them because it's your right under the statute to be given a minimum of 21 days. But what normally happens most of the time is, this is normally something that a lot of employees will seek as compensation when they sue in case there's any termination when they part ways with the employer. So they seek for this. So if I find someone who was terminated, who started working maybe in 2012, but was terminated in 2026, will seek for, maybe they never took any leave days, they seek for it. And court will award it because the law is clear. So the court will not be like, the employer cannot defend themselves by saying, no, you didn't ask for it. It's clear in the law that you have to give minimum 21. Yeah.
So if, for example, I do not take my leave days this year, and I go to court and tell court that I did not take my leave days, so that will my employer pay me back for the days that I did not take as leave days?
No, that one now will depend. Like, if the employer has evidence to show you're the one who decided not to take your leave days, of course now that one you will not have any compensation. Because not what court compensates is when the employer is going against the law.
Okay.
They're the ones who are deciding not to give you those leave days. Yeah.
All right.
So that's what now will depend. Now go down to the evidence also. When do you have the evidence show that they didn't give it to you, and do they have the evidence that you're the one who didn't take it? Yeah.
There's something quite popular nowadays that we see a lot happening, in the employment sector, independent contracting, what others would call now consultancy. Where does that sit in the Employment Act? We see a lot of people going this route, they're employed, they're not employed, consultants are not employees. Then is it a safer way when looking for employment, the consultancy route?
I can say it's safer for the employer.
For the employer?
For the employer, because this person cannot sue you for any employer-employee relationship issue, like for unfair termination, because this one now it will be more of breach of contract. Yeah. So if there's an independent contract, remember, that's what I was telling you, when you go to court, the first thing, you have to make sure that you have a relationship of employer-employee. Nowadays, even I normally see, even in the US, it's very common, employers don't hire directly. You don't have any contract with the employer. They use HR companies. So you find for you, I've employed you, but you don't have any contract with me. Like maybe my company is called ABC company. You're working for ABC company. You don't have any contract with my company. I used a HR company to hire you. So for you have a contract with that HR company. Now see, for that one, it will be hard for you to sue me, to sue ABC company, our company, because you don't have any contract with us. So that's what most even in most countries, Canada, they normally do that to avoid these disputes. Yeah.
Is it safer for the employer or actually puts the employer at risk?
It depends, because I feel as an employer, you have much control if you have direct contract with your employees. But now remember, this time you don't have direct, and also you as an employee, you don't have any contract with this company. So you can do anything, you feel you're free. You don't have any direct contract with them. Yeah, so I just feel it has a certain risk for each party. Yeah, when you don't have any direct contract.
But no one can sue the other.
Yeah, because you don't have any relationship. Because right now you're working for ABC company, but your contract is with a HR company, maybe you'll sue that HR company, but you can't sue now the company you're working with because you don't have any relationship. Yeah.
Walk us through the process of appraisals, and as we come to the tail end of this conversation, a friend of mine was talking about appraisal at their place of work, that she has only been there for about 6 months, yeah, but she has been appraised 3 times within that 6 months. What do you think might cause that exactly? Because now the concern was that only 6 months, her work is being assessed, how she's been doing at work, but there's nothing that is actually being done. Because my thinking is that for appraisal, there has to be something that leads to that, right?
Yeah.
If maybe there wants to be a salary increase, or they want to increase they want to give you another role, right? Then what do you think that would cause an appraisal 3 times within 6 months without anything? Like hakuna salary imeongezwa, hakuna cheo imeongezwa, but these appraisals keep coming up.
I think it will depend, because is this person still on probation?
Yes, they're on probation.
Yeah, because chances are, this is the time the company is trying to see if you are a perfect fit. So most of the time, they normally do them within this probationary period. Yeah, so that by the time they are maybe confirming your employment, they are sure about, the person they are taking, this person is a perfect fit for the company. Yeah, so I think that's, and also it will depend. Most of these companies, you'll find they'll have protected themselves in the policies. Let's see, for such a scenario, we'll have to look at also their policies to see if the policies provide for it. Yeah.
How about one who is not on probation, but they still, if at all, let's say this example that I've given you, what if they were not on probation?
So that one, now, that's what I normally say, I normally don't like giving general advice, but it will depend with the contract and the policies, what it stipulates. Because now it will, because as long as it's not like, it's not like the normal PIP performance, where someone is trying to look at your performance, but nothing comes to, because it will. I think what I can just say, it will depend what is the appraisal for. If they have made it clear to you, this is the purpose for the appraisal, but if it's not leading to anything, it's something that you can raise. Yeah, especially if it's not affecting you performing your work. Yeah.
Okay, what is the minimum time period of probation? Because we're talking about 6 months probation. Is that really something that is legal, or doesn't the law recognize that? Because I know usually there's a 3 months probation, but 6 months?
It's 12, maximum is 12.
A year?
Yeah, a year. The law recognizes a year, but now the law is 6 months, then you can extend for another 6 months. But now it has to be with the consent of the employee, like you extend for another 6 months. Yeah, the law gives a maximum of 12 months for probation period. Yeah, the reason being, here both parties are trying to see if you are a perfect fit for the company. Even you, some people, even you, when you join a company, you want to know if you are a perfect fit for the company. Yeah, someone can say, 1 year is a lot of time for you to be on probation. But the law has provided for at least a maximum of 12 months. Yeah.
All right. So how would you advise an employee who wants to maybe file a case against the employer, as we wind up, and this is your final question in a parting shot, for them to win that case? If, for example, I'm aggrieved and I want to file a case against my employer, what should I do?
So my advice would be get a consultation first from the lawyer. Go to a lawyer, let the lawyer understand the context of your case, then they can advise you, so that at least you know what you're looking forward to. Because sometimes employees, if you don't do that consultation stage, someone might, you see right now, it's through consultation that you'll know the matter might take 3 years. Because someone might come to sue assuming that within 6 months the case will be done. So I normally say get a lawyer to...
6 months? I thought a week we are done.
No, yeah, you see now, people might have assumptions. So I normally say the first place, get a lawyer to... Get a consultation from a lawyer, for a lawyer to advise you based on your case, so that you can even have an idea of, because I normally tell people not all cases it's guaranteed you will win. Some it's going to be 50-50 based on the circumstances. You see, like the one for absconding duty, the employer was justified. So maybe now you look at the procedure that was followed, so that at least you have an idea of what to expect. Yeah, and also I normally tell people, don't assume you will win the case. So even get to know what will be the financial repercussion if I'm to lose that case. Yeah. Though I normally tell people for employment cases, it's not like commercial cases. Even filing employment cases, it's like filing a claim. It's like almost, it's not more than, it's like based on, anyway, it will depend with the attachments you're putting. sometimes when it can go more than 2,000, but now just, I normally tell people for commercial cases, if you're suing for something that is, subject matter is more than 1 million, you pay 75,000 for filing fees. But now for employment, it's subsidized. So even compensation, it becomes, it's less compared to other cases. So sometimes I normally tell people, let that not deter you. I normally see some employees, when you tell them that bit, they're normally scared. They're like, but I tell someone, it's not normally, for employment to prevent, you know, the court is also supporting people to come and fight for their rights. So they can't put a lot of financial burden for you to scare you away from even coming to seek for your rights. Yeah.
All right, workers' right versus employer power. That is Wakili Ruth Tanui, an advocate of the High Court of Kenya, walking us through the thin line between legitimate employer control and violation of workers' rights. So there you have it. You're protected under the Employment Act of Kenya. And at least now you know, if you want to sue, you have to consult your lawyer first. Thank you so much, Wakili, for making time for us to have this pertinent discussion. At least now we know some 1, 2, 3 about, you know, our rights as employers, and of course employees also do have rights, but we'll be talking about employers some other time. Thank you so much for watching. That brings us to the end of this conversation. You're watching Morning Cafe. My name is Anne Odida. Good morning.